My name is Loraine. I decided to do a video presentation for my final, and I decided to choose the second topic to talk about, which is, does the law provide equal protection for women? Jumping right into it, some sources in the Constitution that seemingly provide equal protection to women are the 14th Amendment, the 5th Amendment, and the 19th Amendment. Laws are created to protect women, as they like to say. I think that's a great way for them to justify putting restrictions on women without necessarily saying that. They say to protect it to sound better so that they can still discriminate and have rules against them, but when they're protecting women, it's okay. Starting off with the 14th Amendment Equal Protection Clause states that no state shall deny to any person within its jurisdiction the equal protection of the law. The key word in this, person, so it is necessarily gender neutral, but it's too broad. So that could conclude both men and women, but for most of history in the Supreme Court, this did not interpret this clause as protecting women from any sex discrimination. The Fifth Amendment Due Process Clause is another one that historically does not protect or specifies to protect women. It has been interpreted through male-centered norms, and it lacks an explicit guarantee of sex equality. There's only indirect protection for women, and it tends to have unequal procedural outcomes. Because the Fifth Amendment focuses more on procedural fairness, women tend to face barriers in actually accessing any justice, especially with cases involving any sexual violence or pregnancy-related decisions. So while the Fifth Amendment can protect individuals from arbitrary government action, its gender-neutral language and male-centered application makes it insufficiently protective or even indirectly unfair to women. Although the 19th Amendment did mark a historic step forward, it was still very limited and uneven, meaning that many women still continue to face inequality and exclusion. Although the 19th Amendment did address the right for women to vote, it missed out on a whole lot of other things like equal working rights, employee discrimination, reproductive rights, and protection from sexual violence, which left women still very vulnerable in so many other areas and aspects. Jumping back to the 14th Amendment, the Due Process Clause, the Constitution did not contain an explicit general guarantee of sex equality. So as a result, women's equal protection rights were more so developed through judicial interpretation rather than clear constitutional text. Direct verbiage was not used to clear up any confusion about sex equality. Now jumping into, I did 3 Supreme Court cases that shows that the law still does not protect equal protection. Although we're getting closer, it's still not absolute equality. Starting off with the first case, Reed v. Reed, it struck down on an Idaho law that preferred men over women to be estate administrators. For the first time, the court held that a law discriminating on a basis of sex violated the Equal Protection Clause. Although the court used rational basis language, it applied it more skeptically than normal. This then signaling a shift away from unquestioned acceptance of sex-based clarifications. This case suggests that this law does not provide equal protection by rejecting arbitrary gender preferences. The second case I decided to use, and I apologize if I butcher this name, Frontero v. Richardson. In this case involved a federal law that automatically granted any benefits to male military spouses, but required female service members to prove their husband's dependency. The court argued that sex should be treated as suspect classification, triggering strict scrutiny, emphasizing the long history of discrimination against women. This case does show both advancement, but also limitation. It acknowledges the systemic discrimination against women, but doesn't really do much to provide the strongest constitutional protection they possibly could. The last case I decided to use is United States v. Virginia. In this case, the court struck down on Virginia Military Institute's male-only admissions policy. This excluded women from publicly funded opportunities based purely on stereotypes about their ability. The alternative program for women that they created was not truly equal, which reflects how separate but equal. Also, going back to how this protects women because of their different abilities and their strength levels, but really it's just not including women in everything. On the other hand, equality for women can operate as a double bind, treating them exactly the same as men or treating them completely different can both reinforce inequality. Catherine McKinnon explains more on this topic through her dominance versus differences framework. The differences approach that she talks about highlights how women differ from men and justifies special rules or protections, but this often entrenches stereotypes and reinforces women's perceived weaknesses. The dominance approach, on the other hand, argues that inequality is not about difference at all, but about male power and social hierarchy. Supposedly neutral laws reflect male norms, thus disadvantage women even when women are treated the same. Martha Minow describes a similar related problem as the dilemma of difference. Ignoring gender differences assumes a false neutrality that minors the dominant perspective, which is the male perspective, while acknowledging differences can stigmatize and marginalize women. The real issue is how difference is defined and then used. Together, both these theories show why equal doctrine struggles with gender equality. Both sameness and difference can perpetuate inequality unless the law confronts underlying power structures. Equal protection can coexist with misogyny and gender oppression when equality is understood only in formal terms. Laws may treat men and women the same on their face while still reflecting male norms and reinforcing women's disadvantages in practice. In this way, equal protection can mask rather than eliminate equality. Equal protection is a necessary but incomplete tool on its own. It can challenge misogyny, yet still exist alongside gender oppression. The movie we watched in class, The Hunting Ground, illustrates how legal and institutional responses to campus sexual assault routinely fail women. I'm sure it wasn't a shock to anybody, sadly, how that is how most women are treated in the face of something so serious as sexual assault. These very big and established universities would rather sweep these horrible abuse allegations under the rug and hide them from the public rather than defending and supporting these women that have gone through this abuse. In the documentary, it showed a statistic that really clearly shows how they care more about their public image rather than any actual judgment. It was shown that hardly any of these men that were accused or known to cause any of the sexual violence to anybody were removed from the school, but the schools had no issue removing students that might have cheated on any academic tests or failed to follow through with their academics on that side. But when it came to protecting women, because they didn't want to garnish their reputation, they hid anything related to that. Similarly, in the movie review I did earlier in the year, The Accused highlights how courts and juries would rather scrutinize the victim's behavior rather than the perpetrators, reflecting legal and cultural biases that undermine women's safety and autonomy. And just to give everybody a reminder of what happened in The Accused.
Go for it, Dad!
It's an ugly case. He was gang raped on a pinball machine.
That is the man that was held on a pedestal and the woman that was broken down throughout the whole film. Going back to the central question of my project, if whether the law really protects women and equal rights, like I mentioned previously, I personally do not believe so. I believe most of these laws that protect women are used to control women instead, but the use of the word protect, very misused, is in a way of how these laws are justified. Although they aren't correct, this is what the reality is, and this is what we are still struggling with today. And some of the laws and overturns recently have just shown even more about how the most simple case, and one of the biggest cases that I followed myself for the first time ever, was the overturning of Roe v. Wade. I think just goes to show how even now in 2025, we are still moving backwards and protecting women, reality meaning controlling women.